Council, and I quote what he said, "What we see in Gaza is the erosion of humanity. We are appalled by the Israeli attacks on humanitarian workers in Gaza. The humanitarian workers of the United Nations, the International Committee of the Red Cross, the Palestine Red Crescent Society, UNRWA, FAO, Médecins Sans Frontières and Nasser Hospital have been under fire since the hostilities resumed. We are shocked by the latest attack on the humanitarian convoy, killing 15 medical and humanitarian workers. Slovenia condemns all attacks on all humanitarian, medical and United Nations personnel. They must be protected and supported in their missions at all times. We call for an end to those attacks." End of quote. Mr. President, members of the court, these remarks conclude the oral statement of the Republic of Slovenia. On behalf of the members of the Slovenian delegation, I thank you for your kind attention. Thank you very much for the representative of Slovenia for their presentation.
So the court will observe a break of 15 minutes. The hearing is suspended. Please be seated. The sitting is resumed. I now invite the next participating delegation, Sudan, to address the court, and I call Her Excellency Ambassador Umaima Al-Sharif to the podium. You have the floor, Madam.
Mr. President, Madam Vice President, distinguished members of the Court, it is indeed an honor to appear before you today on behalf of the Republic of the Sudan. The government of the Republic of the Sudan acknowledges the importance of the advisory proceedings requested by the General Assembly Resolution number 79/323 concerning Israel's obligation in relation to the presence and activities of the United Nations, other international organizations, and third states in occupied Palestinian territory. Sudan addresses this distinguished court in the spirit of the UN Charter, guided by its purposes and principles, including the fundamental prohibition against the acquisition of territory by force. These principles resonate with urgency in light of developments that have obstructed the work of the UN Relief and Works Agency for Palestinian Refugees in the Near East, the Relief and Works Agency, and the operations of third states in the occupied Palestinian territory, including East Jerusalem, as mandated by the UN General Assembly. We are deeply concerned by respective legislations imposed by the occupying state, Israel, that has effectively terminated the operations of the Relief and Works Agency in the occupied Palestinian territory, leading to the collapse of the severely needed UN humanitarian response. This outcome is deeply troubling and carries grave implications, not only for the humanitarian response, but also for the broader regime of UN privileges and immunities. Mr. President, the deteriorating conditions in the occupied Palestinian territory further diminish the already vanishing prospects for a peaceful, just and durable resolution for the Palestinian question. The absence of a viable political horizon has led to catastrophic levels of suffering among the Palestinian people. There is now an urgent and compelling need for humanitarian relief. In these dire conditions, the Relief and Works Agency remains a vital lifeline for Palestinian refugees, particularly amidst the collapse of health and education systems and the destruction of essential infrastructure. Its work spans beyond Gaza to include the West Bank and neighboring countries such as Syria, Jordan, and Lebanon. Mr. President, Sudan recalls that the Relief and Work Agency, as a UN entity, symbolizes the international community's recognition of the plight of the Palestinian refugees and expresses a spirit of global solidarity. Since 1949, it has shown itself to be effective, efficient, and indispensable. There is at present no viable alternative to its operations, nor can its responsibilities be transferred until a comprehensive and lasting resolution of the Palestinian question is achieved. Mr. President, I respectfully ask that you grant the floor to Professor Raimondo, who will continue the presentation of our oral statement. Professor Raimondo will address three core elements. First, whether the court should render the requested advisory opinion. Second, the Israel's obligation to respect the sovereign rights of the State of Palestine to engage with third states and international organizations. And third, the Israel's obligation to respect the UN privileges and immunities. His remarks will be succinct yet comprehensive in outlining Sudan's position. Thank you, Mr. President. Thank you, distinguished members of the court.
I thank Ambassador Al-Sharif. I now invite Professor Fabian Raimondo to address the court.
Mr. President, members of the court, it is an honor to once again stand before this court to address the issues outlined by Ambassador Al-Sharif. Objections to the admissibility of requests for advisory opinions from the United Nations General Assembly are neither novel nor uncommon. Yet, the court has consistently and rightly dismissed such objections. I begin by recalling the court's jurisprudence on this matter, which forms the foundation for addressing the current objections. As stated in the court's advisory opinion of 19 July 2024, when a request is submitted, the court must determine first whether it has jurisdiction, and second, whether there exist compelling reasons to decline to exercise that jurisdiction. In the present proceedings, no participant has challenged the court's jurisdiction. Accordingly, I will not address this aspect and will proceed directly to the issue of admissibility. As noted in the 2024 advisory opinion, the existence of jurisdiction does not compel the court to exercise it in every instance. The court retains discretion to decline to render an opinion, but it has emphasized that it should do so only in the presence of compelling reasons. Israel and another participant raised 4 objections. First, that an advisory opinion would prejudge the ongoing contentious case between South Africa and Israel. Second, that the question presented is prejudicial and one-sided. Third, that the court has already addressed similar issues. And fourth, that rendering the opinion would require extensive factual investigations. The first objection is misplaced. The South Africa versus Israel case concerns alleged violations of the Genocide Convention, whereas the present proceedings concern distinct legal obligations relating to the conduct of an occupying power and its treatment of international actors. Moreover, advisory opinions are by their nature non-binding and serve to assist the requesting United Nations body in its functions. Therefore, the risk of prejudicing the contentious case is unfounded and does not meet the threshold of a compelling reason. With respect to the second objection, Sudan recalls that the court has the power to interpret and, where necessary, reformulate the questions put to it. It is for the court to assess the formulation, scope, and meaning of the questions submitted. Accordingly, this objection cannot stand. I now turn to the third objection, namely, the argument that the question before the court allegedly involves matters already dealt with in previous advisory opinions. Although the court has earlier found that Israel violated international law and has an obligation to end the occupation, the current request presents distinct and unresolved issues, especially considering the ongoing humanitarian crisis. It specifically examines Israel's duties as an occupying power and as a member of the United Nations, as well as the role and activities of the United Nations, other international organizations, and third states within and regarding the occupied Palestinian territory. In addition, the reference to the need to ensure and facilitate the unhindered provision of urgently needed supplies highlights the main focus, while also allowing the court to consider related legal obligations. There is no legal barrier preventing the court from giving an opinion in these circumstances, and the short time elapsed since the previous advisory proceedings does not constitute a valid reason to decline. Accordingly, Sudan submits that this objection should be rejected. I now turn to the fourth objection, namely, that the court will need to make significant factual findings not suited to advisory proceedings. The court has already dismissed a similar argument in the previous advisory proceedings concerning the occupied Palestinian territory. It is well established that the court may rely on public information, including from United Nations organs and specialized agencies. In these proceedings, the court has before it extensive materials submitted by the Secretary General. It is for the court to assess the sufficiency of that information, and there appears to be enough to answer the General Assembly's question consistently with the judicial function of the court. Accordingly, Sudan submits that there is no basis for declining the request. Let me now turn to Israel's obligation to respect the sovereign prerogative of Palestine to establish and maintain relations with other states and international organizations, the United Nations among them. In its 2024 advisory opinion, the Court confirmed that Israel, as the occupying power, must not obstruct the Palestinian people in exercising their right to self-determination, which includes the right to an independent and sovereign state across the entirety of the occupied Palestinian territory. As a core element of statehood, Palestine's right includes, and indeed requires, the capacity to participate in relations with other states and international organizations. This is not merely a technical attribute. Without the ability to engage internationally, statehood will be a hollow concept. Denial of this right strikes at the heart of what it means to be a sovereign people entitled to self-determination. Therefore, Palestine is entitled, through its recognized representatives, to develop and maintain relations with other states, the United Nations, and other international organizations. Conversely, other states, including Israel, are obliged to respect that right. This includes diplomatic and consular relations, engagement with international organizations, and the conclusion of treaties, among other sovereign rights. Where such relations are pursued freely by the Palestinian authorities, any effort to hinder them constitutes a breach of the right to self-determination. Likewise, deliberate efforts to obstruct the presence of diplomatic or consular actors in the occupied Palestinian territory infringe upon that right. I shall now turn briefly to Israel's obligation to respect the privileges and immunities of the United Nations. One participant in these proceedings presents 5 claims aimed at justifying Israel's actions regarding the Relief and Works Agency. Each of these claims is flawed in law and in principle. Sudan respectfully contests these claims, drawing upon the Charter of the United Nations, the 1946 Convention on the Privileges and Immunities of the United Nations, and settled United Nations practice. First, functional necessity. It is indeed true that Article 105 of the Charter of the United Nations refers to privileges and immunities, I quote, as are necessary, unquote, for the fulfillment of the purposes of the United Nations. But the interpretation of what is necessary is not left to the discretion of individual states. That interpretation was codified by the General Assembly in the 1946 Convention on the Privileges and Immunities of the United Nations, a treaty in force for Israel. That convention grants the United Nations absolute immunity from legal process unless it has expressly waived that immunity. It follows that the doctrine of functional necessity defines the scope of immunity, but it does not empower states to make unilateral determinations of when that scope has been exceeded. Second, alleged violations of neutrality. That participant claims that the Relief and Works Agency's privileges and immunities can be forfeited due to alleged neutrality violations. This proposition is legally unsustainable. In fact, the United Nations Secretary General is the competent authority to assess whether acts fall within the official functions of United Nations personnel and to determine whether immunity should be upheld. Moreover, the 1946 Convention provides that United Nations property and assets shall be immune from any form of interference, whether by executive, administrative, judicial, or legislative action. That protection is not conditional on the perceived behavior of staff members. Even in cases involving serious allegations, any recourse must be sought through United Nations channels, not through unilateral action that undermines the United Nations' independence and inviolability. This interpretation is confirmed by the Court's advisory opinion of 29 April 1999. Third, substitutability of the Relief and Works Agency. Whether other agencies could, in theory, fulfill the role of the Relief and Works Agency is irrelevant to the question at hand. The legal test is not about indispensability. The Relief and Works Agency is a subsidiary organ of the General Assembly and, as such, falls squarely within the protective scope of the 1946 Convention. Its privileges and immunities do not depend on how replaceable it may be. They derive from its institutional status. Moreover, the General Assembly has repeatedly reaffirmed the mandate of the Relief and Works Agency, most notably in Resolution 64/89, which calls on Israel to cease obstruction of the agency's operations in Gaza. Fourth, state party discretion. Israel cannot lawfully revoke or restrict immunities on its own initiative. The 1946 Convention confers absolute inviolability upon United Nations premises and archives. It further obliges state parties to actively protect these premises from interference, including by third parties. This inviolability includes immunity from physical searches of United Nations vehicles and materials, a point reaffirmed by the United Nations' own interpretation. Any obstruction of movement, searches, or disruption of operations, even if based on security justifications, must conform with Israel's duty of non-interference. Fifth, the Comey-Mitchell-Moore Agreement. That same participant invokes this bilateral agreement to justify Israel's actions. However, the hierarchy of norms under Article 103 of the Charter of the United Nations is clear. In case of conflict, obligations under the Charter prevail over any other international agreement. Furthermore, the Comey-Mitchell-Moore Agreement cannot displace the binding obligations under the 1946 Convention, which Israel accepted in full. As such, no bilateral understanding can lawfully be interpreted to override the core principles of inviolability, immunity, and independence. Mr. President, members of the Court, the framework established under Article 105 of the Charter of the United Nations, the 1946 Convention, and United Nations practice is clear and coherent. The privileges and immunities of the United Nations are not optional. They are not revocable based on allegations or political disagreements. They are the legal foundation that enables the United Nations and its agencies, including the Relief and Works Agency, to operate independently and effectively. Allegations of misconduct, if substantiated, must be addressed through the mechanisms of the United Nations itself. To permit states parties to the Convention to act unilaterally would be to undermine the very integrity of the international legal system and to erode the independence of the United Nations as a whole. Your Honours, I express my sincere gratitude for your attentive consideration. In times like this, when the authority of international institutions is questioned and the principles of international cooperation are at stake, we must confront the harsh reality that the pursuit of international justice is rarely straightforward, and that the ideals we uphold often face formidable challenges. Yet, it is precisely in these moments of trial that our unwavering commitment to the Charter of the United Nations and the fundamental principles of international law must not only endure, but strengthen. Mr. President, I respectfully invite you to request Ambassador Al-Sharif to deliver the concluding remarks of the oral statement on behalf of Sudan.
I thank Professor Raimondo. I now give the floor back to Her Excellency, Ambassador Umaima Al-Sharif. You have the floor, Madam.
Mr. President, distinguished members of the Court, in light of the foregoing, Sudan concludes as follows. First, that the Court has jurisdiction to issue the requested advisory opinion and that no compelling reason exists to exercise its discretion to decline it. Second, that Israel, as an occupying power and a United Nations member, has obligation regarding the presence and activities of the United Nations, international organizations, and third states in the occupied Palestinian territory, which include the obligation to respect the sovereign right of Palestine to enter into relations with other states and international organizations. And finally, that Israel is also bound to uphold the privileges and immunities of the United Nations and its entities, including the Relief and Works Agency, and that its recent actions constitute a serious breach of the 1946 Convention and the Charter of the United Nations. Thank you, Mr. President. Thank you, members of the Court, for your patient attention. Thanks also to the Registry and the staff of the Court for their continuous support.
I thank the representatives of Sudan for their presentation. J'invite à présent la délégation suivante.
I would like to invite the following delegation, the delegation of Switzerland, to take the floor, and I call His Excellency Ambassador Franz Paris to the podium. Mr. President, distinguished members of the court, it's an honor for me to appear before you on behalf of the Swiss Confederation. The dramatic situation in the Middle East, the violence and suffering, the prolonged occupation without any prospect in sight, declared illegal by the court, the atrocities committed on October 7th and since, the suffering of the hostages and their families, the catastrophic humanitarian situation in Gaza, the massive violations of international law by the parties to the conflict, all of this is of deep concern to us. Switzerland supports the UN Security Council's vision in which Israel and Palestine live side by side in peace within secure and recognized borders. And Switzerland is convinced that a lasting peace between Israelis and Palestinians can only be achieved if international law is respected and a two-state solution negotiated in good faith and in accordance with international law is found. Israel has legitimate security concerns, but it also has an obligation to respect international law. Similarly, the Palestinian people have the right to self-determination in order to live in peace, but international law must also be respected in the pursuit of this goal. In recent months, not only have the obligations of international humanitarian law been called into question, but also other obligations due to the United Nations and the humanitarian actors playing an essential role in the occupied Palestinian territory, and with a view to a two-state solution. It is in this context that the UN General Assembly has asked the Court to give an advisory opinion to clarify Israel's obligations in respect of the presence and activities of the UN, other international organizations, and third states in the occupied Palestinian territory. My oral presentation will first briefly highlight some of the obligations incumbent on states with regard to the activities of the UN and other international actors under the UN Charter, the law of privileges and humanities, and international humanitarian law. I will then focus on the issue of security concerns and their influence on these obligations. Mr. President, distinguished members of the Court, by becoming a member of the United Nations, a state accepts the positive obligation of assistance set out by the Charter and is therefore obliged to assist the UN, its subsidiary bodies, and its agencies. The corollary of this positive obligation is that any action aimed at undermining or weakening the work of the UN is contrary to the Charter. A member state, therefore, has not only a positive obligation to assist the UN, but also an obligation to refrain from acting against the organization. And while states have some flexibility in the way they implement their positive obligation to assist, the obligation to refrain from obstructing the work of the UN is in principle more absolute. Regarding the privileges and immunities of the organs of the United Nations Charter and the Convention on the Privileges and Immunities of the United Nations established the obligation to respect the immunities of the organization and its personnel, as well as the inviolability of its premises. Israel acceded to this convention without making any reservations, and as long as Israel is a member of the UN, it cannot denounce this convention. Finally, Mr. President, members of the Court, Since the West Bank, including East Jerusalem and the Gaza Strip, are occupied by Israel, Israel, as an occupying power, is legally bound by the normative corpus of the law of occupation. As Switzerland emphasized in its presentations during the previous advisory opinion proceedings on the occupied Palestinian territory, this body of law must be interpreted in favor of the higher interests of the population living under occupation. Under the Fourth Geneva Convention of 1949, ratified by Israel, when the population of the territory it occupies is inadequately supplied, Israel, as the occupying power, has the obligation to consent to relief schemes in favor of that population and to take all necessary and effective measures to ensure them. The Court also recalled this obligation in the context of several orders indicating provisional measures last year, and in particular stressed the obligation, here I quote, take all necessary and effective measures to ensure, without delay, in full cooperation with the United Nations, the unhindered provision at scale by all concerned of urgently needed basic services and humanitarian assistance. In this context, the occupying power, that was the end of the citation. In this context, the occupying power has an obligation to respect and to protect humanitarian UN personnel. This was reiterated by Resolution 2730, adopted by the Security Council in May 2024 at the initiative of Switzerland. Finally, relief agencies present and respecting humanitarian principles must be able to continue their activities independently of the occupation without any change which might be prejudicial to their activities on the part of the occupying power. To summarize, under the Charter, Israel has an obligation of assistance to the United Nations and its subsidiary organs. Under the Charter and the Convention on the Privileges and Immunities of the United Nations, Israel has an obligation to respect the privileges and immunities of the United Nations and its subsidiary organs. And finally, under international humanitarian law, Israel, as the occupying power, has an obligation to ensure, while cooperating with the United Nations and other humanitarian organizations, the provision of basic services and humanitarian assistance, and to ensure the well-being of the population under its control. Mr. President, members of the Court, I would now like to turn to the issue of security concerns and their influence on the obligations mentioned previously. These clear obligations may, in exceptional circumstances, conflict with legitimate security concerns of a state. Security concerns are not, as such, particularly defined. They are not, however, a blank check, the invocation of which makes it possible to evade international law and legal scrutiny. On the contrary, the fact that security concerns are incorporated into certain rules means that the concept itself is legal. It is therefore, from a legal perspective, that they must be analyzed. As the concept of security concerns is a legal one, judicial review must be possible. The states themselves in their domestic legal systems usually allow judicial review of the measures relating to national security. In order to respect the rule of law, it is necessary for an independent judicial authority to be able to examine whether the invocation of national security is legitimate, so as not to give way to arbitrariness. The invocation of security concerns must not only be justiciable, it also calls for the analysis of objective criteria. Some of these are specific to each legal context, such as the UN Charter, privileges and immunities, and international humanitarian law. I will come back to these elements in a moment. That being said, a number of transversal elements can be identified. The World Trade Organization has already had to deal with the way in which exceptions relating to national security had to be taken into account in order to allow for an exception to certain obligations. In this context, the central conclusion reached by the panels is that the invocation of national security is not purely a subjective exercise of description. Making their existence dependent on the unilateral will of a state would empty the obligations of their substance. In other words, invoking security concerns does not remove a complex of facts from international law and the obligations arising therefrom. A state invoking such concerns is not the sole arbiter of their existence and of the consequences that result from them. To invoke national security concerns, 3 criteria can be identified. Firstly, a state invoking security concerns must identify the security threat in concrete terms. Secondly, the security interest threatened must be clearly and concretely identified. To be a legitimate security interest, it must reach a particularly high threshold. Thirdly, there must be a causal relationship between the threat and the security interest advanced. A security concern that is only vaguely related to the alleged threat cannot be taken into account. With regard to these 3 aspects, the existence of a concrete threat, legitimate concerns for safety, and a causal link, a threshold of objectivity must be reached. This means that all the relevant elements must be presented on the basis of concrete and specific facts in an understandable and verifiable manner. It is not sufficient to rely on a vague threat to justify the invocation of safety concerns.
Finally, the invocation of security concerns must be made in accordance with the principle of good faith. It cannot be accepted if the policy pursued is specifically aimed at inciting disorder. When all the above criteria are met, the response must comply with a number of fundamental legal principles. For example, the principles of necessity and proportionality must be respected. In short, the invocation of security concerns is not a wild card that can be used to avoid obligations under international law. On the contrary, such invocation must be provided for by law. Moreover, it is subject to strict legal conditions, in particular as regards the concrete and objective nature of the factors put forward. This is in the interest not only of the international legal order, but also of the state concerned, as it increases both the credibility and legitimacy of its measures and confidence in its good faith. In view of the foregoing, it would seem appropriate for the Court to address these conditions under which security concerns may be invoked in its advisory opinion. Mr. President, members of the Court, having dealt with the cross-cutting aspects of security concerns, I now turn to the specific circumstances in which they may be invoked. according to the legal areas concerned, in particular, the obligation to provide assistance to United Nations organs under the United Nations Charter, respect for the privileges and immunities of United Nations organs, and the obligation to support and agree to relief schemes under international humanitarian law. With regard to the UN Charter and the duty to assist the organization, Article 2, Paragraph 5 of the Charter does not provide for any explicit exceptions to this obligation. Nevertheless, actions undertaken by the organization must be in accordance with the provisions of the Charter for them to give rise to a duty of assistance on part of the states. If a state were to consider that a UN body was endangering its national security through its behavior, it would have to put this forward in a concrete manner. Once the facts have been substantiated and the evidence transmitted, the UN would then be able to investigate, shed light on the problem, and take appropriate measures. This is, for example, what was done in the case of UNRWA, through the investigation by the UN Office of Internal Oversight Services and the measures taken by UNRWA. In addition, the Colonna report made 50 recommendations to further strengthen the neutrality of the organization, which Switzerland expects to be fully implemented. The report also underlined that UNRWA has put in place a significant number of mechanisms and procedures to ensure respect for humanitarian principles. UNRWA and its mandate remain relevant to a two-state solution and the creation of a Palestinian state with the means to resume these services. Mere rejection of the agency or its mandate as established by the General Assembly cannot constitute a legitimate security concern in and of itself. Furthermore, UNRWA continues to play a central role in the provision of quasi-state services such as health or education to the population of the occupied Palestinian territory, as well as in the provision of humanitarian assistance. It can be presumed that the United Nations, including through its agency UNRWA, acts in conformity with the provisions of the Charter. However, it cannot be ruled out that legitimate friction points may arise in relation to Israel's security. In such circumstances, the notification of security concerns based on concrete and verifiable facts to the UN, be it the General Assembly, the Security Council, or the Secretary-General, is appropriate. The duty to assist the UN requires the search in good faith for a common and discussed solution, in the interests of both parties, and not the imposition of unilateral measures. It should be noted that in the event of a substantive dispute between a state and the UN, the court may be asked to give an advisory opinion. In the meantime, states are bound by their duty of assistance to the UN and must not hinder the organization's work. With regard to privileges and immunities, international law allows any security concerns to be taken into account. For example, if a state wishes to have access to the premises of the UN or to initiate criminal proceedings against one of its officials, it must request the lifting of the inviolability of the premises or of the immunity of that official from the UN itself, in a specific case clearly stating the reasons for the request. As a host state, Switzerland has always been able to count on the cooperation of the UN in accordance with the Convention on the Privileges and Immunities of the United Nations when problems arise in Switzerland in connection with UN officials' benefiting from immunities. This procedure, which has proved effective, has the advantage of allowing progress to be made on two levels. On the one hand, if the immunity is waived by the organization, the state will be able to bring criminal proceedings against the persons or the person concerned in compliance with the procedural guarantees provided by international law. On the other hand, the organization is thus informed of the alleged facts and can, for its part, take action on the basis of its internal regulations. It goes without saying that under no circumstances is a state authorized to take unilateral measures that impede the proper functioning of the UN. Finally, Article 30 of the Convention on the Privileges and Immunities of the United Nations allows a state in dispute with the UN to have recourse to the court to have the dispute settled in a legally binding manner. In short, states must respect the immunities of the UN and its staff. If a concrete and substantial security concern arises, it must be demonstrated verifiably. On this basis, a solution must be sought through discussions with the UN. If a satisfactory solution cannot be found, the state retains the option of referring the case to the International Court of Justice. Mr. President, members of the Court, I now turn to the way in which security concerns are taken into account in international humanitarian law. In the context of occupation, international humanitarian law reconciles the military and security needs of the occupying power with the need for protection of the local population. The rules of international humanitarian law take account of security concerns in the sense that this body of law already reflects a balancing of security interests with respect for the rights of the people it protects. In this context, it is important to note that while some rules explicitly allow security considerations to be taken into account under certain conditions, such as Articles 27 and 63 of the Fourth Geneva Conventions, other rules do not provide for such considerations, such as Article 59 concerning the obligation of the occupying power to agree to relief schemes if the population of an occupied territory is insufficiently supplied. However, even if a rule explicitly provides for security considerations to be taken into account, a state does not have complete discretion in invoking and applying them to a given situation. In addition to the conditions set out in the text of the rule itself, such as the temporary or exceptional nature of the measures, the criteria I have already mentioned of objectivity and specificity remain applicable. In addition, the restrictions in question must be necessary to ensure security, and the consequences for the public must be proportionate to the objective of ensuring legitimate security. With regard to the activities of relief societies, the occupying power is obliged to agree to and facilitate relief schemes by impartial humanitarian organizations if the population of an occupied territory is inadequately supplied. These organizations must be in a position to continue their humanitarian activities necessary for the maintenance of essential services. Only temporary restrictions imposed on an exceptional basis because of a real and urgent danger to security are permitted. Furthermore, the occupying power does not have a subjective and absolute right to determine whether a relief society does not meet the requirements of neutrality or impartiality. These elements must be established objectively. As far as the UN is concerned, the starting assumption is that it acts in compliance with these principles of neutrality and impartiality. The International Court of Justice must be able to rule on whether a party to a conflict is arbitrarily denying humanitarian access, whether such jurisdiction is based on the Convention on the Privileges and Immunities of the United Nations or another treaty of international law remains a question for further consideration. We encourage the Court to analyse in depth the scope of security concerns in the context of international humanitarian law, bearing in mind that the objective of that law is the protection of the victims of armed conflict. Mr. President, members of the Court, allow me to briefly summarize the essence of my remarks. A member state of the United Nations has a duty of assistance to the organization and its organs and agencies under the Charter. While it has some flexibility as to the extent to which it engages in support of the UN, it must refrain from obstructing the work of the organization, and it must respect the privileges and immunities of the UN in accordance with the Convention of the same name. Or, as Senegal has just stated, Israel has an obligation to ensure, to refrain and to respect the United Nations, its organs and agencies. Finally, under international humanitarian law, it must allow and facilitate the relief efforts of impartial humanitarian organizations, including the UN, when the population is in need. These clear obligations may, in exceptional circumstances, come under tension with certain legitimate security concerns of a state. This being the case, the invocation of security concerns, insofar as this is provided for by law, is not a new exception. It is an implementation of existing law. And calling upon security concerns is not a blank check, but must be based on legal considerations. These legal considerations, in addition to those provided for by the rule in question, include three criteria in particular. The state must firstly respond to a concrete threat aimed at, secondly, a particularly high national security interest, and it must, thirdly, establish a causal link between the two. These three elements must be demonstrable and concretely and objectively proven in a way that is verifiable, what's more. The measures taken must also respect certain principles, including those of necessity and proportionality. Finally, international humanitarian law does not allow for a security analysis that would have the effect of falling below its standard of protection. In case of dispute, a state may not act unilaterally, but must seek, in good faith, a joint solution with the United Nations. If need be, the International Court of Justice is there to help resolve disputes. I thank you for your attention.
I would like to thank the representative of Switzerland for his presentation, and now invite the next delegation, the delegation of the Comoros, to take the floor. And I call His Excellency Ambassador Yusuf Mondoha Asmani to the podium.
I now call His Excellency Ambassador Yusuf Mondoha Asmani to the podium.
Mr. President, members of the court, it is an honor for me to appear before you today to express the position of my country, the Union of the Comoros, in the present proceedings. The Union of the Comoros has never ceased to support multilateral efforts to achieve a just and lasting solution to the Palestinian situation. It has historically been firmly and strongly committed to the realization of the Palestinian people's right to self-determination, including its right to an independent and sovereign state within secure borders recognized by international law. In this respect, the Union of the Comoros would like to point out that it is one of the United Nations member states which voted in favor of Resolution 79/232, adopted by a large majority by the General Assembly and requiring an advisory opinion from the court. In participating in these advisory proceedings, the Union of the Comoros is convinced that you will make a decisive contribution to changing the situation by letting the law speak in the present case. I would like to make a few introductory remarks regarding the context of the present proceedings before letting Dr. Guy Fleury-Nentoiri and Professor Pierre-François Laval address certain legal aspects which the Union of the Comoros would like to emphasize. Distinguished members of the court, the Union of the Comoros would like to recall that the Palestinian people are being subjected to an unprecedented humanitarian crisis. This is not the right place for me to refer to the events unfolding at this very moment in the occupied Palestinian territories. This is not why we are here. But I must say, Mr. President, that I cannot help but think of the plight of the martyrs of Gaza, like many of those who are here before you. The images that we are receiving are haunting. They show us women, children, the elderly, innocent people whose lives are ending in fear, in terror, and the horror of indiscriminate and savage bombings. Who can possibly be indifferent to the sick who have succumbed to the worst sufferings with no one able to do anything to relieve them? How not to think of all those broken souls wandering aimlessly without help, with nothing left but their starved, parched, disease-ridden bodies? How not to think of the women whose children are miraculously born in the smoking ruins, only to die because we are unable to keep them alive. In short, Mr. President, lives, destinies, and hopes are being destroyed by a calculated destructive rage which, according to the Special Rapporteur on the human rights situation in the Palestinian territories occupied since 1967, said, and I quote, reveals a deliberate campaign of connected incidents which must be considered cumulatively. End of quote. This situation has been exacerbated by a strict blockade resulting in critical shortages of food, drinking water, and medicines, plunging the population into acute food insecurity. In addition, the health situation is catastrophic, with the environment contaminated by millions of tons of debris, including unexploded ordnance and human remains. Moreover, the Union of the Comoros respectfully reminds the Court that it has itself considered that there is a real and imminent risk of irreparable prejudice to the rights of the Palestinians of the Gaza Strip who need to be protected against acts of genocide. In this context, the presence and activities of the United Nations, its bodies and agencies, and other international organizations, as well as other well-intentioned third states, are crucial to the survival of the Palestinian people and to the satisfaction of the primary needs of the civilian population. In particular, the Office of the United Nations High Commissioner for Human Rights, the United Nations Office for the Coordination of Human Affairs, but above all, the United Nations Relief and Works Agency for Palestine Refugees in the Near East, that is to say, UNRWA. UNRWA plays a key role in managing humanitarian aid and assistance to the Palestinian population. The Union of the Comoros recalls that, thanks to its missions, UNRWA ensures access to education and health, as well as emergency relief, including food aid benefiting more than 1.2 million people. The cessation of its activities without a credible alternative would worsen the already catastrophic humanitarian situation in the occupied Palestinian territories. To conclude this brief introduction, allow me to point out, Mr. President, that your court has already largely clarified what the law says about Israel's conduct towards the Palestinian people and its territory in its opinions of 2004 and 2025, but also in its orders for the indication of provisional measures in the contentious case brought against Israel by South Africa. In this latter case, the court ordered the State of Israel to, and I quote, take immediate and effective measures to enable the provision of urgently needed basic services and humanitarian assistance to address the adverse conditions of life faced by Palestinians in the Gaza Strip, and not to impede in any way the delivery of urgently required humanitarian assistance. End of quote. Since then, it is indeed deplorable that no attention has been paid to this. On the contrary, the illicit action denounced has been amplified. These violations must stop, and we must make this very clear. Mr. President, international law is the sacred edifice that we must preserve. The Union of the Comoros suggests that the court shows this by declaring that international law commands the State of Israel to put an end, as soon as possible, to the unjustifiable and blatantly unlawful occupation of the Palestinian territories, that the court commands Israel to take without delay effective measures to enable the provision of the basic services and to remedy the difficult living conditions to which the Palestinians of the Gaza Strip are subjected. Mr. President, members of the court, I would like to thank you for your attention, and I would like to ask you to give the floor to Guy Fleury-Nettoiry so that he can elaborate on certain aspects of the obligations of the State of Israel in the occupied Palestinian territories. Thank you. I would like to thank Ambassador Assoumani, and I would like to give the floor now to Dr. Guy Fleury-Natwari. You have the floor. Mr. President, members of the Court, it is an honor to appear before you today to clarify the position of the Comoros on the legal content of Israel's obligations. First of all, the Union of the Comoros notes from the written submissions that there is consensus on certain points among the participants in these proceedings. These include the Court's jurisdiction to render the advisory opinion requested, the absence of compelling reasons which would lead it to refuse to render its opinion, but also the fact that measures taken by Israel hinder the activities of the UN, including UNRWA, and constitute a violation of Israel's obligations under the Palestinian people's right to self-determination. Under international humanitarian law, the obligations incumbent upon the occupying power under international human rights law and under the international law of immunities. The Union of the Comoros notes and recalls that it fully subscribes to it and refers to its written statement for the development of the underlying legal arguments. Mr. President, members of the Court, the Comoros would like to focus today on certain questions raised by some delegations in their written submissions. Indeed, it has been argued that the State of Israel cannot be qualified as an occupying power in the Gaza Strip, and that UNRWA is not an impartial body, which has led, according to some, to an obligation to withdraw from the 1967 exchange of letters. The Union of the Comoros strongly contests this erroneous interpretation of certain fundamental principles of international law. Mr. President, first of all, the Union of the Comoros wishes to recall that a territory is considered occupied when it is placed de facto under the authority of the enemy army, and that it was by applying this definition that the Court qualified the State of Israel as an occupying power in its advisory opinions of 2004 and 2024. In the latter opinion of 2024, the Court clearly found that, and I quote, Israel remained capable of exercising and continued to exercise certain key elements of authority over the Gaza Strip, including control of the land, sea and air borders, restrictions on movement of people and goods, collection of import and export taxes, and military control over the buffer zone, despite the withdrawal of its military presence in 2005. This is even more true since 7th of October 2023. End of quote. Consequently, the Union of the Comoros notes that Israel continues to exercise effective control over the Palestinian territory since the Court's last opinion, and consequently that its characterization as an occupying power still persists. Furthermore, the Union of Comoros notes the inconsistencies in Israel's claim. On the one hand, Israel contests its status of an occupying power, but on the other hand, it uses that very status, at least implicitly, to justify its initiatives with regard to UNRWA. Secondly, the Union of Comoros strongly disagrees with the argument that UNRWA's lack of partiality justifies the laws passed by the Knesset for two reasons. Firstly, UNRWA, which it should be recalled, was set up to provide assistance to Palestinian refugees. UNRWA conducts its activities impartially. In this respect, the Union of the Comoros deplores the campaign launched by the Israeli authorities to equate UNRWA with Hamas and to portray the UN agency as promoting terrorism. These accusations are erroneous and unfounded. The Union of the Comoros believes that they also pose a dangerous threat to UN personnel worldwide. It is also very important to understand what the concept of impartiality means in this case, contrary to what certain isolated positions may affirm, which associate this notion with the promotion of a political agenda rather than with the strict application of the law, or with biased representations of the conflict raging in the region. Impartiality within the meaning of the Geneva Conventions, and as this court was able to affirm in 1986 on the basis of the fundamental principles proclaimed by the ICRC, in this sense there is no doubt that UNRWA is an impartial humanitarian organization. Secondly, the Union of the Comoros recognizes that Article 63 of the Fourth Geneva Convention provides for an exception to the occupying powers' obligations towards humanitarian organizations in the event of, quote-unquote, imperative security considerations. However, this exception is interpreted strictly by the ICRC, which states that under no circumstances may an occupying power invoke security considerations to suspend in a general manner any humanitarian activity in occupied territory, unquote. Contrary to what the Israeli authorities assert, the Union of the Comoros maintains that the exception in Article 63 is not applicable to the situation in the Palestinian territories insofar as the activities of relief organizations such as UNRWA, the Red Cross, or the Red Crescent in no way constitute an imperative threat to the security of the State of Israel. Moreover, while the United States is right in stressing that the occupying power can indeed modulate its humanitarian obligations according to the circumstances, these obligations do not disappear. The phrase, to the fullest extent of the means available to it in Article 55 of the Fourth Geneva Convention is only intended to take account of the material difficulties which an occupying power may have to face in time of war, as the ICRC stated in its commentary. And it is also specified that this power is under an obligation to use all the means available to it. In any case, even if these exceptions were to apply, they do not in any case allow for the adoption of general and absolute measures with regard to humanitarian assistance. Only specifically strictly necessary and proportionate measures may be adopted by the occupying power. Thus, Israel's laws prohibiting all UNRWA activities are general and absolute measures and therefore unlawful. In this respect, the Union of the Comoros notes that the otherwise undocumented allegations made by the State of Israel concerning infiltration of UNRWA by Hamas are limited to Gaza and make no mention of UNRWA's activities in the West Bank and in East Jerusalem. Consequently, the hindrance of UNRWA's activities in these two other territories is manifestly disproportionate. Moreover, the State of Israel admits in its written statement that it does not intend to hinder humanitarian aid or any other humanitarian assistance to the civilian population by adopting the law putting an end to UNRWA's activities. In practice, however, no measures have been taken to ensure even a temporary handover to UNRWA. Furthermore, the Union of the Comoros recalls that the provision of humanitarian assistance is a lawful activity under general international law and in no way requires the prior authorization of the occupying power. At most, the occupying power may organize the delivery of humanitarian aid, that is, check the entry of goods needed by the civilian population, and regulate the times and the routes of their passage. Indeed, as the court stated in the case concerning military activities in and against Nicaragua, and I quote, there can be no doubt that the provision of strictly humanitarian aid to persons or forces in another country, whatever their political affiliations or objectives, cannot be regarded as unlawful intervention or as in any other way contrary to international law. End of quote. According to the court, in order not to be regarded as an unlawful intervention in the internal affairs of a state, assistance must be given without discrimination to all in need in the territory concerned. This is the case with UNRWA's activities. Finally, the Union of Comoros respectively respectfully request the court to rule that Israel's withdrawal from the 1967 exchange of letters is unlawful and has no bearing on UNRWA's presence in the occupied Palestinian territories. It should first be noted, as indeed other participants to these proceedings have already pointed out, that this exchange of letters does not create any new obligation for Israel. These obligations exist independently of this exchange of letters by virtue of other treaties. Moreover, the provisional agreement, as constituted by the exchange of letters of June 14, 1967, does not give the state parties the option of denouncing it unilaterally. At most, its provisions make the full implementation of Israel's commitment to facilitate the work of the agency conditional on military security considerations. Israel's claim to unilaterally terminate the commitments accepted in 1967 is thus contrary to international law, and more particularly contrary to the customary rules of the law of treaties as codified in the 1986 Vienna Convention on the Law of Treaties, according to which, and I quote, "A treaty which contains no provision regarding its termination and which does not provide for denunciation or withdrawal is not subject to denunciation or withdrawal." End of quote. This was a quote from Article 56 of the Vienna Convention. The two exceptions allowed by this same rule provide that withdrawal remains possible if it is established A, that the parties intended to admit the possibility of denunciation or withdrawal, B, that a right of denunciation or withdrawal may be implied by the nature of the treaty. These two exceptions cannot provide a legal basis for Israel's claim either, insofar as no intentional element is apparent from the negotiations surrounding the conclusion of the agreement in 1967, and that these agreements establishing an international institution or relating to its activities are not by nature acts which states may denounce unilaterally. As noted by others, the revocation of obligations entered into in 1967 required negotiation and required a consensual basis. The court itself calls for a reciprocal obligation of organizations and host states to cooperate in good faith when it comes to revising a headquarters agreement. In any case, even if the denunciation were valid, Israel, in accordance with the customary law codified in the 1986 Vienna Convention, can only exercise its right of revocation by giving 12 months' notice. During this period of notice, Israel must continue to respect its obligations under international law with regard to the Charter and UNRWA. Furthermore, the Union of the Comoros respectfully recalls that the State of Israel cannot exercise any sovereignty over the occupied Palestinian territories. Consequently, it cannot prevent the Palestinian people from determining which form of humanitarian assistance they need and wish to accept. Thus, the Union of the Comoros fully endorses the arguments made by several participants that the State of Israel cannot prevent the Palestinian people from cooperating with the United Nations or other organizations or states with the aim of realizing their right to self-determination. Mr. Chairman, Mr. President, members of the Court, I would like to thank you for your attention and respectively ask you to give the floor to Professor Pierre-François Laval so that he can explain the consequences of the breach of international obligations thus established. Thank you for your attention.
I thank Dr. Nanpari. I'd like to remind the delegation of Comoros that you have 60 minutes left. I'm prepared to give some extension, but please bear in mind that you have limited time available.
Merci, Monsieur le.
Thank you, Mr. President. Mr. President, members of the Court, it's an honor for me to come before you to present the views of the Union of the Comoros regarding the consequences of the breach by the State of Brazil and its agents of their international obligations. Some who have already spoken here at this podium have claimed rightly that in this case, what is at stake is the survival of several million people. Others have claimed The court simply does not have the obligation nor even the ability to determine the lawfulness, or rather the unlawfulness, of Israel's conduct and its legal consequences. The Union of the Comoros would like, therefore, to begin by saying that the exercise by the court of its advisory jurisdiction in no way restricts it to only identifying applicable law. Several times with advisory opinions, the court has established the existence of violations of international rules that it had identified previously. In July's opinion already regarding the situation in the occupied Palestinian territory, the court said it was held by its judicial function to determine itself the lawfulness of the policies and practices mentioned by the General Assembly. The Union of the Comoros believe also that the purpose of the request and the way it was worded excludes from the mandate of the course the question of the Israeli responsibility. Let us recall that the General Assembly required in its resolution adopted in December that Israel should discharge without delay all legal obligations imposed by international, included those stated by the court. Thus, the Union of the Comoros would like to stress the consequences that flow from the breach by Israel of its international organization. It will recall that the depriving of humanitarian assistance the Palestinian population is criminal, that such as can constitute an international crime that would engage the criminal responsibility of those individuals, including agents of Israel that are responsible. Furthermore, the violation by Israel of its obligations calls into question its own responsibility for internationally wrongful act. These 2 points will be developed in succession. Regarding, first of all, criminal responsibility. Need we, at this stage, recall that depriving a population of humanitarian assistance and causing intentionally great suffering or inflicting bodily or mental harm are acts that may amount to war crimes and genocide? And is it necessary today, again, to recall that starving deliberately civilians as a method of war by depriving them of goods necessary for their survival, by preventing delivery of humanitarian aid, is a blatant violation of the Geneva Conventions? Need we recall that the UN personnel must be protected against any harm likely to prevent it from carrying out its duties? And this means that today the Palestinian population cannot access water, food, and primary health services. By impeding relief efforts, the Israeli government is deliberately taking the risk of creating a widespread starvation. This has been observed by the General Assembly and the Special Rapporteur for the occupied territories, that has noted that the deliberate destruction of infrastructure that are already precarious when it comes to health services amounts slow genocide by attrition. We would like also draw the court's attention to stopping UNRWA's activities may reveal intention to destroy in part or wholly the Palestinians as a group. The Israeli Minister of Finance said earlier this year that it was justified and moral to starve all of the population of Gaza, even if 2 million people were to die as a result. Altogether, the measures adopted by the Israeli authorities that are aimed at depriving the population of services provided by UNRWA amounts to a conduct from which can be inferred the intent to commit genocide. Having talked now about the criminal responsibility for agents, now we need to talk about the responsibility of Israel as a state for internationally wrongful acts that can be attributed to it by applying what is provided for by the 2001 draft articles. First of all, Israel has and undeniably breached its international obligations because of the previous actions accomplished by its agents and leaders that engage their individual criminal responsibility, but also create a responsibility for the State of Israel that its agents have served and continue to serve today. The Union of the Comoros has also recalled the fact that the laws adopted by the Knesset in October of 2024 are breaches of Israel's international obligation vis-à-vis the Palestinian people and vis-à-vis the UN. Because of all of these facts and in application of the obligations in the draft articles, Israel must cease its unlawful behavior and provide assurances and guarantees of non-repetition that are appropriate if the circumstances so require. Furthermore, it has the obligation to repair fully the injury caused. A reparation can take one of the forms described in Articles 35 to 37 of the draft articles, and that are restitution, compensation, if restitution is materially impossible. And of course, this is the case when it comes to the numerous victims of Israeli actions, or finally satisfaction if the former two are materially impossible, and you will render your opinion on this. And also, basis on the draft articles, these obligations of cessation and reparation can be owed to the international community as a whole, based on the nature and the content of the international obligation that is breached and the circumstances of the breach. In this regard, the Union of the Comoros asserts that impeding, interrupting the humanitarian work of the UN is a transgression of some obligations that are erga omnes. This is the case with the intransgressible rules of international humanitarian law, the right of peoples to self-determination, or once again, the prohibition of genocide. The breach of these obligations entails the application of rules of responsibility for serious breaches under Articles 40 and 41 of the draft articles that is applicable in the case of serious breaches by the state of an obligation that flows from a peremptory norm of general international law. Under these articles, these breaches are serious if the violation shows that there has been a systematic and gross failure to discharge the obligation, and the Union of the Comoros notes that the violations committed by Israel vis-à-vis its international obligations were not only committed in a way that was organized and deliberated, but also show a direct attack against those values that are protected by the international rule. This regime on serious breaches has two serious consequences. First of all, it poses on all states to not recognize as lawful a situation that is created by the serious breach and to cooperate in order to put an end to it. Then, under Article 48, all states can invoke the responsibility of Israel. As for Israel, it is not released from his duty to perform the obligations that have been breached by his conduct, as is recalled by Article 29. And first is the obligation to no longer impede humanitarian aid to the population, and in fact the obligation to facilitate it. We could also cite the other international obligations, those that are incumbent upon Israel as a result of its status as an occupying power. Finally, we must also talk about the rights that the UN derives from the violation of its privileges and immunities and also its agents, and that Israel is assuming as a member state of the organization. The Union of the Comoros observes once again that by ignoring the privileges and immunities for UNRWA and its staff, the Israeli law adopted on October 28, 2024, basically is a breach of international law, in particular a breach of Articles 104 and 105 of the UN Charter, Articles 2 to 7 of the Convention on the Privileges and Immunities of the UN, the 1967 agreement between Israel and UNRWA, and also the Convention on Privileges and Immunities of Specialized Agencies. And we might say that here that there is no military reason nor any disposition of Israel's domestic law that can justify non-compliance of the obligations vis-à-vis the United Nations. With these observations, we have finished the presentation of the Union of the Comoros, and I thank you for your kind attention.
For their presentation. This concludes this morning's sitting. The oral proceeding was resumed this afternoon at 3 p.m. in order for Tunisia, Vanuatu, the League of Arab States, the Organization of Islamic Cooperation, and the African Union to be heard on the question submitted to the court. The sitting is closed.